Hello everyone and welcome to UK Property Accountants, your guide to property tax excellence. In this video, we will be talking everything about de-enveloping. In recent years, the practice of holding residential properties in corporate structures, often referred to as enveloping, has come under increased scrutiny and regulation in the United Kingdom. De-enveloping UK property refers to the process of removing a property from a corporate envelope or wrapper, often involving offshore company or trust structures, and transferring it into personal ownership. This practice has gained significant attention due to changes in tax legislation and increasing regulatory scrutiny. In year 2013, ATID is introduced. The UK government introduced ATID to discourage offshore corporate structures holding UK residential properties, imposing an annual tax on properties over £500,000. In year 2015, CGT exemptions are subject to restrictions. The government restricted CGT exemptions for non-residents on gains from UK residential properties, reducing offshore tax advantages. In year 2017, inheritance tax rules undergo changes. Changes to IHT rules now include UK residential properties owned by non-domiciled individuals and offshore structures, closing the loophole of avoiding IHT through offshore holdings. In year 2019, capital gains tax for non-residents is altered. CGT scope expanded to include indirect disposals of UK property by non-residents, making them liable for CGT on shares in companies that derived at least 75% of their value from UK property. In year 2022, ROE is introduced. Economic Crime Act introduced registration of overseas entities, mandating overseas entities to register the beneficial ownership details of the UK resident companies. Regulatory changes such as the introduction of the annual tax on enveloped dwellings, changes to capital gains tax regime for non-residents, and changes to inheritance tax rules, introduction of ROE regulations have removed the tax benefits associated with offshore property holding structures. Following are the de-enveloping options: distribution in specie or dividend in specie, distribution of property in the liquidation or winding up of the company. While de-enveloping UK property hold enticing benefits, it is important to carefully consider the tax implications and other factors involved. To understand everything better, let's see an example. There's Alex, a property owner facing a common dilemma. He owned a property within the UK through a British Virgin Islands BVI registered company. Despite the company's success, Alex found the corporate structure cumbersome and costly to maintain. Alex, who is a non-UK resident for tax purpose, is the ultimate beneficial owner of the property. The property was purchased for £50,000 in 1992 and had a market value of £600,000 at the time of de-enveloping. As the property value has increased substantially from 1992, the appreciation in property value is £550,000. Assuming the corporation tax rate applicable to the company is 25%, the capital gain would be daunting £137,500. But there was a way out of this. Alex can rebase the property when de-enveloping by taking the property value from 2015, as he is a non-UK resident for tax purpose. On April 5, 2015, the market value of the property was £465,000. The chargeable gain is reduced to £135,000 after rebasing. The CGT payable on the transfer incurred after rebasing was £33,750, which is 75% lower than the original amount to be paid. We hope this video has been helpful and informative. If you have any questions or comments, please feel free to leave them below. And don't forget to subscribe to our channel for more UK property taxation and finance videos.